I am Shubhanta Sarkar, Assistant Professor of Mathavangar College. Today I am going to introduce topic 4 of my course, the right to constitutional remedies or Article 32. The Article 32 of the Indian Constitution confers the right to remedies for the enforcement of the fundamental rights of an aggrieved person. This is in itself a fundamental right. This right makes the fundamental rights real. Without these fundamental rights, other fundamental rights will be meaningless. That's why Dr. B.R. Ambedkar called this article as the most important article of the Constitution, an article without which the Constitution would be a nullity. It is very soul of the Constitution and the very heart of it. The Supreme Court said that the Article 32 is a basic feature of the Constitution, so it cannot be taken away even by an amendment. Four provisions of right to constitutional remedies. In order to protect fundamental rights, the Article 32 contains the four following provisions. A person can approach to the Supreme Court with a request to protect his fundamental rights if his right is violated. The Supreme Court can issue directions, orders, or writs, including in the nature of habeas corpus maintenance, prohibition over into and statutory for the enforcement of rights. We'll later discuss about these writs. And thirdly, without adversely affecting the powers of the Supreme Court, in this respect, the Parliament can empower any other court to exercise all or some of these powers within the local limit. And the right cannot be suspended except as otherwise provided for the Constitution. The first writ is habeas corpus, that is issued by the Supreme Court. Habeas corpus means to have a body. It is an order issued by the court to a person who has detained another person to produce the body of the dead person before the court, and the court will examine the legality of his detention. If his detention is illegal, then the court would set him free. It is the bulwark of individual liberty. This right can be issued against both public authorities and individuals. Second, writ is mandamus, which means we command. It is a command issued by the court to a public official, asking him to perform his official duties that he failed or refused to perform. It can also be issued against any public body, a corporation, an inferior court, a tribunal, or government for the same purpose. Prohibition. Literally, it means to forbid. It is issued by a higher court to a lower court or tribunal to prevent the latter from exceeding its jurisdiction. This right can be issued only against judicial and quasi-judicial authorities. Certiorari. Literally, it means to be certified or to be informed. It is issued by a higher court to a lower court or tribunal if there is the grounds of excess of jurisdiction by the lower court. This writ could be issued against only judicial and quasi-judicial authorities. Co-oriental. Literally, it means by what authority or warrant. It is issued by the court to inquire into the legality of a claim of a person to a public office, hence it prevents illegal usurpation of public office by a person. This writ can be issued in case of substantive public office of a permanent character. During emergency, besides the Supreme Court, the High Court also has the power to issue various writs according to Article 226. It is for the concerned person to decide whether to approach the High Court or the Supreme Court. The right to approach the Supreme Court or High Court for the enforcement of fundamental rights, however, can be suspended during the emergency. This is all about the right to constitution.